sometimes you should not argue on quashing, you should not argue on discharge, and you want to straight away move to trial. And this is one very interesting story that I have to share with everybody over here. A couple of years ago, this man came to me, said that he is accused under Section 376 of the IPC for rape. And now the charge sheet was filed, summons were issued to him, and he had to appear before the court. He had already gotten bail at a much prior occasion by the Sessions Court. Now, so he did not spend any time in custody, but now his difficulty was that he, being a police officer, was suspended from duty pending this Sessions trial case. And until this case would wrap up, he would be suspended from duty, and that was a big impediment for his career. So he asked me, what is the quickest way to get over this situation? I explained to him that, and of course, he was not very, police officers, especially, sub inspectors. I believe he was a sub inspector. At that kind of a level, they're not really very legally literate. They don't really know much about, I mean, they should, because they are police officers at the, in this particular matter, I explained to this sub inspector with the police that if he wants the quickest conclusion to his trial, or his case for that matter, the best thing to do would be to not argue on charges at all, because practically speaking, and the situation might vary from state to state in this country, but assuming it to be Delhi, because that is what my practice area has been, and I'm quite confident that the scenario is more or less the same. In fact, if anybody else is from a different state and the timeline is a little different, I would love to hear that in the comment section as well. So in Delhi, what would happen is, assuming that you face maybe the accusation of any offense under the IPC or any other law, what's going to happen is that you are summoned by the court. The charge sheet is filed, the court takes cognizance, issues summons to you, you appear before the court, and then you submit your bail bonds, and then the matter is fixed for arguments on charge. And I believe that that is the place where, especially if there is a false accusation, especially if you believe that you have a very strong case on the merits, you should not wait for, or you should not waste time on arguing on the charges. And this is what I told this client as well. I explained to him that in an offense of rape under Section 376, the allegation being there, no matter, unless there is a complete absurdity in the statement, right, where, say, perhaps in a very absurd and a very stupid example that I'm giving, say a woman says that he pointed his gun at me and he fired the shot and therefore he raped me. That could be completely absurd, and I'm talking about similar absurd situations. In an absurd situation, yes, that FIR could be quashed. But perhaps in a situation where the woman says that this man took me to this place, he committed rape upon me, and I am coming before you now, maybe after a delay of 6 months or a year, and now I'm reporting this case. Even in that kind of a scenario, I say it is much more difficult to get a charge sheet quashed or get a discharge for that matter, and it is wasteful for the client as well, and I'll explain why. When matters are fixed for arguments on charge, usually a good 2 or 3 month long adjournment is given by the trial court. After that, arguments take place. After that, the court likes to, on most occasions, hear arguments maybe once more, or maybe pass orders. Usually, from my experience, it takes a minimum of 6 months, and sometimes when judges are on leave, the prosecutor is on leave, the defense counsel is not available, a global pandemic hits the world and everything goes for a toss for 8 months, or any other circumstance, or maybe lawyers are on strike, which happens so often all the time. Today, a judge told me in an appeal that I have a prosecution witness that I need to examine. So if you don't mind, can I fix a short date for both the parties over here, and we can hear arguments on the next date? And I was cursing myself inside for even conceding to this request of the judge, because I know that on the next date of hearing, when I already have a favorable order in my favor, that in all probability the next date of hearing, either the judge will be on leave, or there will be a court strike, or the government might say there is a lockdown, or there might be counsel for the other side will be unwell, or I might be unwell, right? My client might be unwell. There could be some, the lockdown of the court or whatever reason, and then the matter will again get thrown forward. And that is one major growl that I have. In any case, even in these matters, when you are arguing on charges, what will happen is the minimum time it will take will be around 6 months, and it can stretch on to even 2 or 3 or even 4 years for that matter. And it is absurd the kind of time it takes just on the aspect of framing of charge, where the jurisprudence set down by the Supreme Court and all the high courts always narrows the scope of the possibility of a discharge or quashing or whatever way for the charges to be thrown out at the outset. It is very narrow. And why do you want to deal with that kind of a scenario is something that you need to introspect on, especially if you have a very strong case on the merits. I mean, this is in this case as well. I told the client, you have a great case on marriage because the woman says that he took me to this place and he used to rape me, whereas that place was filled with 6 to 8 tenants belonging to this client of mine. And this woman had completely concocted a story where she was, in fact, she had sold her property, she had taken an advance payment, then she did not want to transfer the title in the property to this person. And when he insisted on it, she then filed a false rape case against this man. I said, you have a ton of proof with you. You just need to show it to the judge at the appropriate time and you will get your acquittal very easily. And for that to happen, the quickest way you want to do it is you do not want to argue on charges at all. Instead, what you want to do is to tell the judge, we understand the law on charges. We ask you to frame charges as you deem fit. But what we request of you is to call the witness, issue notice to witness to appear before the court, the so-called complainant in the matter, as soon as possible. Because we know that the first day that she gives her deposition, we will be able to break her testimony in cross-examination. And within 3 months or 4 months from now, I will be able to get an acquittal for my client. And this is precisely what I told the judge as well. The judge gladly framed charges immediately and fixed the matter for 3 months from that date and summoned the witness to appear. And I knew that if the judge did not go on leave or the prosecutor is not there or some other calamity does not befall us, I will be able to get an acquittal 3 months down the line on that very day itself. Unfortunately, and this is why this is a very fond memory of mine, which I'll explain in a couple of minutes, you'll understand why it's a fond memory, is that we walk out of the courtroom, this client of mine meets, bumps into another lawyer that he knew from before. He says, ye hamare vakil sahab hain, इन्होंने हमारे डिपार्टमेंट के बहुत केसेस करे हैं. He's a very well-renowned advocate. So the advocate Saab says, okay, what were you doing over here? What kind of case do you have? And so he tells us, he tells the case. He asks me about the update on the case and asks me what happened. I told him that I just went and told the judge, you may frame whatever charges you want. We want the witness in the stand. We are going to cross-examine and break the witness immediately. The lawyer, this really old, sophisticated, really successful lawyer says, oh my God, what have you done? How could you not argue on charges? And he says, this is completely unacceptable. My client is, looking at this really young, naive, dumb-looking lawyer who just said, I'm foregoing on charges. It's completely all right. And he looks at this senior lawyer and says, oh my God, this guy says I just ruined my whole case. So he grabs the file from me, rushes with the so-called senior lawyer inside the courtroom and begs the judge. The judge says, no, the damage is done. So the man calls me up and tells me, you have ruined my life. तुमने मेरी जिंदगी बर्बाद कर दी है with this kind of a step that you took. And I tried to explain. The guy would not understand. Very well. Fast forward 1 year. The man then compromises the matter with the woman, pays her a lot of money. Then they together file a compromise petition before the Honorable Delhi High Court. Notice is issued, arguments happen, and after precisely approximately 1 year and some come give or take a few days, the High Court says, in the circumstances, the allegations which are there, we are not inclined to, in a compromise mutual quashing petition under section 482 CRPC, we are not inclined to quash this matter. And the matter again goes back to the trial court. This man who tells me on one date that I have ruined his life, calls me exactly after 1 year, give or take a few days, and tells me, you know what, this so-called senior lawyer, he ruined my life. And I couldn't help but laugh on his face and remind him that these were the precise words that he told me as well. Ultimately, what happened was the woman went, she's already taken the money, and she now went before the court and gave her testimony that this was a false case, and I don't know. And then the man gets acquitted precisely 1 year and 3 months from the date that he left me, where I had told him that you can be free without paying any money to the woman in 3 months. It took him now 1 year and 3 months. And this was a valuable lesson for me as well, where I saw as a junior advocate, this happened several, I think, a good 3, 4, 5 years ago. This happened where, you know, just because every single lawyer says that this is the way the things are done in the court, does not mean that you, as a young lawyer or a law student who is about to become a lawyer, will also do. You need to understand that the justice system in this country, be it the civil procedure, be it the criminal procedure, be it any of the substantive laws, there is always a lot of scope for you to be innovative, almost like an entrepreneur, and come up with new solutions. Maybe the trial court judge, also set in their ways, might not appreciate them, but trust me when I say this, the best high court judges are all judges who were practicing as lawyers for several decades. They themselves are quite innovative, and I can definitely say that, at least for the Delhi High Court, which is full of extremely brilliant judges who practiced as brilliant advocates for several decades. And when you present a strong, sustainable argument in front of them, they will appreciate it and they will act upon it. I myself have had several great experiences arguing matters before the Honorable High Court and the Honorable Supreme Court, and I've had great results with very, very out of the box thinking, if I may say so myself. Of course, sometimes this kind of out of the box thinking might not be really appreciated, but I think all things considered, these are these are some of the things that you kind of have to remember.